This second mini video is continuing on our medical assistance in dying discussion, and we are on the PowerPoint page 8, and where we're looking at the requirements. So just to refresh, in the passage of Bill C-14 and the decriminalization of medical dying, the Trudeau government, who had kind of inherited this file as they came in, asked for a bit of extra time. But in the end, they came up with a bill which didn't quite go as far as the court case did. And this becomes an interesting point in our discussions as we move forward, because it really all comes down to issues of consent, capacity, and things like advanced care planning and powers of attorney. But at this point, the bulk of the issues get passed through into law. So looking at the requirements, we lay out 5 key requirements here. So first of all, you have to be eligible for health services funded by a government in Canada. So that means you can't do the tourism that we see in some other countries, such as Switzerland. You have to be an adult, and you have to be able to make your own decisions with regards to your health. So you have to be a capable adult by law. You also have to have a grievous and irremediable medical condition. And so there's a lot of discussion around what is grievous and what is irremediable. Obviously, irremediable means it's not going to get any better, but the discussions about whether something is grievous and irremediable is one of the areas where people find there's a little bit of flex. There has to be a voluntary request for medical assistance in dying, which I'm just going to call MAID for short. And in particular, it was not made by any form of external pressure. And this is a significant concern about many in the disabilities community, is that there will be pressure for people who perhaps have profound disabilities, or for people who have significant mental health issues, to kind of just give in, and that there will be people who would wish them to choose a medical assistance in dying over a life with accommodation. And so you can't have any externalized pressure. And the voluntary request means that you as a capable adult need to be able to make that request. So then it goes back to the stuff that we're talking about. It's about informed consent. So you have to be able to give informed consent after having been informed of the means that are available to relieve your suffering, as well as all discussions about palliative care being included in that. So you can't really just go and say, oh, I want MAID, and then without having gone through this significant checklist. So let's build that out a little bit. And to the next slide, which talks about grievous and irremediable medical conditions, which apparently says medial conditions. I apologize for the typo. So it needs to be a serious and incurable illness, disease, or disability. You need to be at an advanced state of irreversible decline in your mental capacity or your capability, and that illness, disease, or disability, or the state of decline causes physical or psychological suffering intolerable to them, and they cannot be relieved under conditions they consider acceptable. So conditions that they consider acceptable is an enormously important part as well. And the natural death has become reasonably foreseeable, taking into account the circumstances without a prognosis necessarily having been made as the specific length of time that they have remaining. So you don't need to have 10 days or 6 weeks or 6 months specifically to have your natural death be reasonably foreseeable. Let's move on to restrictions. So we see that you have to have quite a process to go through. You need 2 independent medical or nurse practitioners agree that the person meets the eligibility criteria, so 2 independent ones, and 10 clear days between the request and the provision of MAID, unless the death is extremely imminent, and there may not be that amount of time. So clear days means that if it's on a Monday, the clear day starts on a Tuesday, and it will finish the day before a medical assistance in dying would be given. So it's not 8 days with 2 extra days. It really is 10 clear days. So it looks like 12 days, if you will. They must have the opportunity to withdraw their request, and they must give express and personal consent to the procedure. So you can't have mature minors, which is interesting because it really wasn't one of those limitations in the court case. So this is a narrowing of the discussion. And I'm just going to skip to the bottom one. You cannot get MAID on the basis of a mental disability, or, if you will, more specifically, a psychosocial disability. So this is not for people with mental health issues, despite the fact that that similarly was not covered as a restriction in the court case. But the most important piece here is that there's no advance request or advance consent for medical assistance in dying. And that really becomes one of the most defining features of medical assistance in dying discussions right now. So I put some of the stats, and I gave you the web link as well, which is constantly keeping up with the statistics. Unsurprisingly, that there's been a greater kind of wait list of people who've been wanting medical assistance in dying and been trying to see which way the decisions would be made and whether it would be put in law. So there's a little bit of a pent-up need, but it is evening out, and that there are requirements provincially as well. It won't surprise you to know that there are new legal challenges already underway. And so we see that, again, the BC Civil Liberties Association, this time represented with the representative plaintiff of Julia Lamb, is challenging the reasonable and foreseeable death requirement. In Quebec, Paul Saba challenged the case as well, saying that it actually goes against the Quebec Code of Ethics on the Physicians and Health Act. And we also have another Quebec case, and some of you will know the cerebral palsy case of Nicole Gladue, and she challenged that Quebec laws are restricted on a natural death and foreseeable end of life on the basis that they are too vague. On the other side, we see a man by the name of Roger Foley who had a serious neurological disability, and he is claiming that he was pressured to give consent to MAID, and that he was not given enough home care, adequate supports, and that this assisted death was what was given to him rather than an assisted life. In the interpretation section, we're starting to see a number of cases come through about what some of these terms mean. So we see that there's an interpretive decision in Canada versus AB in the Superior Court of Justice, which is the trial division of Ontario, which held that a natural death need not be imminent, and what is a reasonable foreseeable death is person specific. And so there's starting to be some discussion about what these interpretations mean. Until very recently, we really had a lot of issues with regards to conscientious objections. So there was a case brought forward saying that offering medical assistance in dying was an infringement on the physician's freedom of religion, and with regards to providing equitable access to health care, and there was a leave of appeal. There was just a court case a few days ago which came down and held that even in the case of referrals, that the physicians must make a referral even if they themselves are not willing to perform medical assistance in dying, but they must help and refer to others who would do that. And we're going to take a break and move, actually,